have to cut all that now. Thank you.
Why? What are you, a moil? I'm sorry.
We saved those jokes for the flagship podcast, not for this very...
Don't you mean the flagship podcast?
Put together podcast.
I'm sorry. Go ahead.
So we have a new case to discuss today. Murray...
Aren't you going to welcome them to this podcast?
No. That's what the classical music does. They're settled in with their scotch and whatever they're drinking.
Water.
So Murray versus UBS Securities, LLC.
Yeah.
This case is very much what constitutes a whistleblower and what they need to prove in termination.
Okay.
So we'll get into that. So in 2011, Trevor Murray was hired by UBS Securities as a stock and financial strategist. And as part of his job, he had to write financial reports and do research about the state of the company, UBS Securities.
Okay.
His two immediate supervisors began asking him to basically doctor some of the reports that he was writing and some of the research.
No.
They wanted, quote, for him to produce research that supported UBS's business strategies by maintaining a consistent perspective across organizations, trading desk, and research.
Oh.
So Trevor Murray reported feeling pressure and the unethical nature of these requests to his even higher up supervisor, a man named Michael Schumacher. And Schumacher, like any shady businessman would, said it was not right for his supervisors to ask him to do such a thing, but did nothing to stop it. Basically, he was saying, oh, shame on them, but I'm going to let him keep doing it anyway.
Get that research done.
Right. So during a routine evaluation, a little bit later, Murray told Schumacher, his upper supervisor, so this was January 2012, that the situation was getting worse. And, right, he told him that the situation was getting worse, and Schumacher responded to do as his bosses told him. So basically reversed his, oh, poor pitiful you, back to, well, just do it. After the meeting, Schumacher emailed his superior asking that Murray either be transferred to another job or be fired.
It's a little bold.
So, shockingly enough, Murray was then fired in February of 2012 for basically not playing ball.
That's so stupid for an organization to do. You basically don't fire anyone unless they, threaten you at this point.
Well, so that's where this case sort of goes, right?
Right.
So, this is very interesting in a specific reason. So, Murray obviously sued the company for wrongful termination, but he did so under a very specific statute. So, the Sarbanes-Oxley Act of 2002
right.
Was written and approved by Congress after the Enron scandal.
Right.
And so it aimed to improve auditing and make business practices more transparent, things like that. But it also wrote into the law a protection for whistleblowers in these situations where they were whistleblowing about unethical things. Right,
because I think that was a big factor in Enron, is that there were people who knew that there were things that came up, but then they didn't feel protected in saying anything.
Right.
So, and other companies at the time. It wasn't just Enron. People forget that.
Right. But they were the
biggest name.
Right. So Murray contends that he was fired due to his complaints about the illegal, unethical activities of his supervisors. And so the New York District Court had a jury case for this, right? So it was not it had 12 members of a jury. It wasn't like a judge deciding it, right?
Right.
And per the jury instructions, let me find the quote here, sorry. So, the jury was instructed that Murray and his counsel were to prove that his activity was a, quote, contributing factor in his termination of employment, not the primary motivating factor.
Oh.
So the jury came back, obviously siding with Murray, saying, okay, it may not have been the primary reason for his termination, but it was a contributing factor.
Right, enough to make a difference.
Right, enough to push the scale, right?
Right.
So UBS appealed, claiming that Murray should have had to prove retaliation. So he should have had to prove that he should have had to come up with irrefutable evidence, that he was fired for the sole reason of his complaints and his whistleblowing, which is kind of impossible to do in a way. So the Second Circuit Court agreed with UBS and vacated the jury verdict, basically saying, yeah, he should have had to prove that his termination was based solely on his complaints, on his whistleblowing. So now we're here, Supreme Court, right? So I want to read the pertinent part of the Sarbanes-Oxley Act as it states.
Okay.
So it says, quote, no company or any officer, employee, contractor, subcontractor, or agent of such company may discharge, demote, suspend, threaten, harass, or in any other manner discriminate against an employee in the terms and conditions of employment because of any lawful act done by the employee, to provide information, cause information to be provided, or otherwise assist in an investigation regarding any conduct which the employee reasonably believes constitutes a violation of blah, 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 Securities and Exchange Commission.
Right.
So basically, the act says you cannot fire someone for aiding in an investigation or whistleblowing about unethical activities, right?
Right.
The act also very nicely lays out that a person who is claiming wrongful termination in these cases must file a complaint with the Secretary of Labor of the United States, who then will do an investigation.
Okay.
The act says very clearly the burden of proof is it's very clearly laid out. The Secretary, quote, the Secretary of Labor shall dismiss a complaint filed under this subsection and shall not conduct an investigation unless the complaint makes a prima facie showing that any behavior described in paragraphs 1 through 4 or subsequent blah, 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 I won't read the whole thing, was a contributing factor in the unfavorable personnel action.
Right.
Contributing factor.
Right.
And prima facie meaning
on the face
obvious,
of the evidence. Yeah.
So it very clearly says not a primary factor, but a contributing factor. So the original jury instructions that were provided in the original case were correct.
Right.
So now we're on the question of what is the burden of proof for this man and for any whistleblower really in the future, right?
Right.
So the burden of proof for an investigation for the Secretary of Labor is what I just read, not a court burden of proof. So that's another place where the question we're bringing this into question, right? So it's unclear what the difference should be. Should there be a different burden of proof for an investigation done by the Secretary of Labor and then something you have to prove in court, or should they be the same?
Right.
So
that's confusing.
It is confusing.
It's confusing because it feels like it puts a lot of pressure on a whistleblower.
Right.
In this case, because you now have to petition the Labor Department and everything on your side.
So Murray asserts that an employment discrimination claim only needs to have proof of causation, not intent. Mm. And this doesn't have legal precedent, right?
Yeah.
So we have nothing to go off of by this. UBS, however, contends that Murray's language analysis is misplaced because the phrases contributing factor and motivating factor only refer to degrees of causality, not the employer's intent. So we're getting to the question of, I guess UBS is basically saying the causality of his whistleblowing leads to his termination.
Right.
But you have to now prove that it was the employer's intent to fire him for the whistleblowing.
But that's impossible.
I would think so. I would think that would be very...
nearly impossible.
Right. You would basically have to have an email or phone call...
We're firing him for this.
Right. A phone call recording
of
someone saying, we're going to do something illegal now.
Well, my other question with a case like this is you were talking about his employment was in 2011 and he was fired in 2012.
Yeah, a long time ago.
More than 10 years past this.
That's what the justice system does, apparently.
But how would you feel if that was your job and you were fired and you have to get a job somewhere else and you have to be in court and you have to follow up on all these things 10, 11 years later? Mm-hmm. I mean, what is restitution for something like that if they do find out that he was unlawfully terminated for something? I mean, do you have to then also include all the attorney's fees and then the time and the stress and all that? That's a long timeline. Most people would just give up. If they said, okay, you can get this money, but you have to wait 12 years for it. Nobody's going to do that. They might die in 12 years.
Right. But really if you're going into any legal scenario and any legal battle, you're kind of under the impression that this is going to last for 10 years.
That's why everyone's doing arbitration nowadays. Yeah. I mean, everyone's just kind of stepping in like, all right, let's get in a room. This is you. Let's move it along. Like whatever the decision is, the decision is.
But yeah, no, the overall question of if you're a whistleblower in a case like this or in for a financial company who's doing unethical or illegal things and you're terminated for whistleblowing, do I have to... I think it's fair enough to say that I can prove that it's a contributing factor, right, but I can't prove that it is the primary factor.
It is going to be really interesting for us to go back and look and find out, because no one's going to actually do the work, but what information did they want him to doctor? I'm curious about that, because this was a few years after the financial crisis and homes were still very cheap, but they were still like reticent to put out loans and stuff like that. Like, what financial data did they want him to juice? That I would love to find out. Because then if that's the case, then what are they doing now? What do we not know about now in our current fragile economic state? So that's another thing that we're going to find out in 10 years about, like, oh, this whole time then when they said inflation was going down, oh, no, that wasn't right.
Well, I wonder, because I've read many, in doing research for this, I read many articles about it, but I didn't dive deeply into the original court documents where maybe some of that information was shared.
Yeah.
So it's possible that we do know some of that already, but it wasn't written in some of the articles about it. But
yeah.
Getting to the law of this, though, as I've said before, originalist conservative judges like Thomas and
right,
and Alito and stuff. What's the other one? Because Kavanaugh and
Thomas, Alito, Kavanaugh, Gorsuch.
Thank you. Because Kavanaugh and Amy Coney Barrett are institutionalists. They're not strict conservative originalists.
Yeah.
So,
which is why I would not have chosen either of them. But
the strict conservative originalists like Clarence Thomas, he's probably the number one.
And Alito, spicy Alito, has been a surprise the past few years.
Right.
And Gorsuch, who is, I think, Trump's best pick.
I'm wondering how they're going to rule on this, because they bring up a good point. Again, as I read from the statute, the burden of proof was dictated for the investigation, but not for legal proceedings, right? Not what you have to prove in court.
Right.
So are you going to make that equivalence and make that jump of, oh, well, if it's good enough here, it's also good enough for a court of law? And how these originalists are going to translate the statute or interpret the statute is the best way to say that.
That's an interesting point, because if
you're going strictly originalist, it doesn't say, the law doesn't dictate how the court, how the burden of proof should play out in court. It dictates how it should be.
Because then it throws it back to case law for whistleblower case law. Besides Sarbanes-Oxley, like there's other whistleblower case law about.
Which is why I'm curious why Murray's original counsel had him choose that particular.
Yes, why would you choose something so new? And in any situation, and even if it's not a financial institution, if you have a whistleblower and there is unethical, illegal, whatever practices, they call it out and you fire them for any reason. If you're like, they just show up late a lot. Well, but you told them not to do this, or you told them to do this and they didn't want to, or this wasn't right.
Right.
There's plenty of retribution, and retribution beyond just, I mean, maybe he didn't want to do this for the money. That's the only way I can understand it, because you can have an attorney step in and say, well, but then he wants, if you do this, he wants $1 million, and then an RBS can afford to write a check. I hope. I don't know. Maybe that's what the financial data showed. It couldn't.
Maybe.
But I think that if they really want to push this to maybe create some kind of precedent, then I can understand them going under something like a Sarbanes-Oxley Act.
Yeah, no, I think that's the main problem is they built their case on this one act and chose it for a reason, and I'm not sure what the reason was.
Maybe it was to set precedent. So we'll see. Even if it ends up being the 3 originalists are not into it, that's still 6-3 decision.
True. Well, depending on how the liberal justices go. I don't know.
Yeah. I had a very annoying encounter with RBS at one point. I think it was RBS.
UBS.
A few years ago. UBS.
This is called UBS.
Oh, I thought it was RBS.
No.
Well, I don't know UBS.
I don't even know where they're from.
No, they had the commercials on Fox News. I remember it was called You and Us, UBS. I remember how weird those were.
Really?
I was like, I don't want that. What do you mean you and us? I'm not with you. I don't know who you are. You're just some faceless bank.
Oh, see, I tried to find information on this company and I couldn't find much. So I don't know who or exactly what they do. But it's going to be interesting, I think.
Agreed.
And potentially, again, as we said, precedent setting, especially because this act was not thoroughly written. I don't know. We'll see.
Again, that anything Dodd-Frank, anything that happened after a financial crisis or recession, any legislation that happened after then is usually hastily written. And I'm not saying this is some criticism just in general, but it's true. They made processes that normally would take a couple of years to consider and tried to condense it into a month to get it out there. So there's going to be more situations like this that happen, to the point where then every few years or every 10 or so years, they're like, well, fuck it, let's just write a new bill.
Yeah. I'm going to be interested to break down the opinions once they're written and see how the justices weighed in on this. But
yeah.
As for now, case dismissed.
Well,